In life, shit happens. Illness, getting hit randomly by a car, getting caught in an epic battle between King Kong and Godzilla. Nickelback. What do you need to protect your home? Your car? Your money? What about your creditors? When you die, some, but not all of what you leave behind is considered part of your estate. For example, the estate of Balthan Esquire, whose unfortunate death from exposure to terrible music from a Canadian alt-rock band was well documented. The process of figuring out who inherits what from the estate is called probate. In probate, the deceased person's surviving family members ask a court to decide what to do with his possessions and debts. Probate can be a long and arduous process. Sometimes it's better to skip it altogether, or try to make it as painless as you can. But how? Today, let's look at the difference between two types of protection you can get: a trust and a will. We don't want to delve too deep into it. After all, this is a random video on the internet and it's not meant to be taken as legal advice. To put it simply, with a trust, you create a new entity. For example, the Balthan School for Kids Who Can't Read Good and want to learn to do other stuff good too trust. You will then transfer any assets you want to protect into the trust's name. It's a process called funding the trust. Now the trust owns everything. You own nothing. Congratulations, you've now lost everything you worked for in life. Just kidding. You see, when you die, there's no assets for the court to administer into probate. So you get to be the master of your own fate. It's not so simple though. You must designate someone to run the trust and give that person power over what to do with the assets. This person is called a trustee. You can then designate a person, or more than one person, who will benefit from the assets in the trust, called appropriately the beneficiaries. This is usually where you put the names of the people you want to leave your stuff to. In some cases, the person creating the trust, the trustee, and the beneficiary can be the same person. But now we're getting more into rich people trying to hide assets than estate matters. So why do this? When a person dies, what happens to the assets owned by the trust are decided by the terms of the trust, not by a court. So property can be divided and distributed to the beneficiaries, and the trust dissolved, without ever having to go through the probate process. And the dead person's debt might not need to be dealt with because the estate does not have any assets. So why doesn't everyone just create a trust? Well, the upfront cost can be expensive. There are tax implications with transferring of assets. There are also costs associated with upkeeps and accounting and reporting requirements. So for people without a lot of assets, it may not be worth it to spend all of that money. With a trust, you do get to skip the inheritance tax, but if you're in Florida and have less than $11.4 million in assets, you don't have to worry about that anyway. Remember when I said, if you have to go through probate, there are ways to make it easier? That's what a will is. A will is a piece of paper telling the court what you want to happen to your assets when you die. Who would handle the paperwork? Who will be responsible for making sure that your debts are paid? Who will inherit what? And who you will disinherit, if you're that type of person. Just make sure you sign the will the right way. That is, in front of two independent witnesses and a notary. And try to preserve the true copy somewhere safe. So, in conclusion, you either front load the cost of assets transfer and inheritance with the trust so you don't have to deal with probate, or you make it as clear as you can to the probate court what you want to happen to your assets with the will and have your surviving family members deal with the cost of probate. You're dead anyway. What do you care? Always remember.
Mama always said dying was a part of life. I sure wish it wasn't.